Today, every VAWA bill we've considered in the last 20 years had three things in common. It's been bipartisan, it's been written in consultation with advocates and service providers on the front lines for domestic violence, and it has sought to further protect battered women and other victims of serious crime. This bill shares none of those attributes, and the amendment offered by Ms. Adams, or will be offered, we've seen it, does not change that. Unlike any VAWA bill before it, the bill was developed without any input or support from the minority or the leading domestic violence advocates. It rolls back protections for battered spouses, victims of serious crimes such as rape and sexual assault, and it does so by weakening or entirely repealing provisions that have been in law for decades and that were approved by near unanimous consideration of this body in prior years. Let's be clear, this bill weakens or repeals provisions that had near unanimous support of Democrats and Republicans in past years. Each of the provisions was either added or expanded in the Republican Congresses in 1996, 2000, and 2005. In the year 2000, the Chris Smith bill that first created the U visa and extended VAWA protections would have passed unanimously if not for the single no vote of Mark Sanford. The 2005 bill from Jim Sensenbrenner that further expanded these protections first passed the House overwhelmingly, 415 to 4, and then on voice vote after it was amended in the Senate. Now, rather than following in this bipartisan tradition, and rather than work to ensure that women are further protected from this abuse, this bill does the opposite. It would be the first time that Congress would weaken protections for victims and actually empower abusers to do more harm. That this bill is worse than current law should not be in dispute. The bill is opposed by every leading domestic violence organization, including the National Network to End Domestic Violence that represents over 2,000 domestic violence advocates and service providers across the country. These are not partisan groups. They are the organizations in every state, including in each of your districts, on the front lines against domestic violence. Joining them are the leading faith-based groups, including the U.S. Conference of Catholic Bishops and the National Association of Evangelicals, which also provides services for battered women and which strongly oppose the rollback for immigrant victims in this bill. We checked with them. They still oppose the rollbacks for battered immigrant women in the bill, even if the Adams Amendment is offered and adopted. Now, it's not every day that the National Organization for Women and the evangelicals agree, but they do in this case, and I think it's one of the reasons why you should look favorably on the amendment that we will offer, which is the exact same amendment bill that was passed by the Senate. Now, in addition to the religious groups and the domestic violence opponents and service providers, law enforcement agencies and officers with years of fighting domestic violence have supported the Senate bill and indicate that the provisions in the House bill will hamper the fight against our districts, indicating fraud related to VAWA. The committee held no hearings on whether fraud exists in the program. Indeed, there was no hearing on VAWA at all. There was no hearing on the bill or whether the changes proposed would actually eliminate fraud or even increase it. And even though the committee members drafted this bill without input from domestic violence advocates, there was no hearing on how the proposed changes might affect battered women seeking help. There was no process around this bill except for a single markup where the majority justified its rollback of longstanding, bipartisan, and critical protections for domestic violence victims on nothing, absolutely nothing, but a few anecdotes of possible fraud that were raised for the very first time at that markup. Even now, we don't know enough about the anecdotes to look into them, verify them, or refute them. The only anecdote we do know anything about is one story cited by the chairman over and over again at the markup. And if true, this was an individual who was called by the Senate, and there may have been an issue, but it was a single instance in 1998. That is the basis for rolling back these protections. We don't know much about the other anecdotes thrown around at the markup. Some of those peddling these stories have been exposed as having a financial interest in seeking protections for battered immigrant spouses weakened or repealed. All you have to do is Google the word these days, and you quickly figure out who lines up where. To the rollbacks in H.R. 4970 are domestic violence advocates, battered women's shelters, university scholars, researchers, the Catholic Church, evangelicals, national women's organizations, law enforcement officers who fight domestic violence every day. And the only groups who openly support these provisions are groups like SAVE and A Voice for Men, who align themselves not with battered women, but with the spouses found by the government who have abused them. You should read for yourself the federal jury verdict finding that the treasurer of SAVE and the owner of a mail-order bride company, Natasha Spivak, intentionally refused to tell a pregnant Russian immigrant who was being severely beaten by her U.S. citizen husband about VAWA protections so she could protect her business in its 95% success rate. Or maybe you should read SAVE's website and how it trumpets as a key fact that, quote, female initiation of partner violence is the leading reason for women becoming a victim of subsequent violence. You should read also the statement of A Voice for Men that belittles women, and you'll see that these are advocacy groups that you may not wish to be associated with. The manager's amendment doesn't address the gaps in protection and services for victims who are battered or abused. It contains very troubling new language about the ability for Native American women to obtain judicial protection orders. The committee needs to ask itself whether it wants to align itself with the bipartisan Senate where every single woman in the Senate, Republicans and Democrats, voted for a bill, or whether you want to be the outliers on protecting women and others against violence. I would hope that we could work together in a bipartisan way, as the Senate did, reject the bill that came out of the judiciary, and instead adopt, as an amendment in the nature of a substitute, the bill that the Senate reported that is a collaborative bipartisan bill. It's offered by Mr. Conyers and Ms. Moore and myself, and which we recommend very much to you.
Thank you very
Mr.
much,
Chairman.
Ms. Lofgren. Let me just say to